Morning, students. Today we will study the chapter Union Executive, President of India. This is part 1 of the chapter that includes an introduction, term, qualifications required, and method of electing the President of India. This lecture is for students studying Indian administration. Objectives of this chapter are to make the students understand President as the constitutional head and the election process of the President of India. Introduction. As per Article 52 of the Constitution of India, there is to be a President of India and he is the head of the state. As per Article 53, the executive powers of the Union are vested in the President and are to be exercised by him either directly or indirectly through officers subordinate to him. Term of the office of the President. According to Article 56 of the Indian Constitution, the President of India holds office for a period of 5 years from the date on which he enters his office. He can be re-elected again. He may cease to hold office if he resigns by sending in the resignation addressed to the Vice President of India or is removed from his office by the process of impeachment for the violation of the Constitution of India. Office of the President. Notwithstanding his term's expiration, that is ending of the term, the President shall continue to hold office until his successor enters upon his office. In case of resignation, the Vice President is to communicate the same to the Speaker of the House of the People, that is the Lok Sabha. In case the President resigns, dies, or is impeached, then elections are required to be conducted within 6 months. The Vice President acts as the President till the new President is elected. In case the Vice President is unable to act as the President, then the Chief Justice of India, or in his absence, the senior-most judge of the Supreme Court, acts as the President of India. We cannot keep the position of the President vacant. Qualifications. The qualifications required for getting elected as the President of India are, and these are as per Article 58, Clause 1, he must be a citizen of India. He must have completed the age of 35 years. He must be qualified to be elected as the member of the Lok Sabha, House of the People. Article 58, Clause 2 states that a person is not eligible for election as the President of India if he holds any office of profit under the Government of India, the government of any state, or any local authority under the government. Conditions of the President's office. Article 59 states that the President cannot be a member of either House of the Parliament or the House of the State Legislature. In case he is a member, he is deemed to have vacated his seat in that House on the date on which he enters upon his office as the President of India. The President cannot hold any office of profit. The President is entitled to a rent-free official residence. Such emoluments, allowances, and privileges as the Parliament may determine from time to time. The emoluments and allowances of the President cannot be reduced during his term of office. The President. According to Article 54 of the Indian Constitution, the President of India is elected by an electoral college consisting of the elected members of both the houses of the parliament, that is, the elected members of the Rajya Sabha, the upper house, and the Lok Sabha, the lower house, and the elected members of the state legislative assemblies. State includes the National Capital Territory of Delhi and the Union Territory of Puducherry having legislative assemblies. Members of the state legislative assemblies have been included to ensure that the president is elected from a wider electorate rather than being elected only by the members of the parliament. In the election of the president, the nominated members of both the houses of the parliament and the state legislative assemblies do not vote. Reasons for indirect election. An electoral college indirectly elects the President of India due to the following reasons. We all know that the President's position is that of a constitutional head and not the real head. Direct elections in the whole of the country will be a very costly and time-consuming exercise, and that too for a constitutional position. If we have direct elections, that will make the president more powerful as compared to the Prime Minister of India, who's the real head. And because the President of India is a constitutional head, but will be having more power due to direct elections, so there can be a chance of conflict between the Prime Minister and the President of India. Weighing of votes. As stated earlier, we have come to know that the MPs and MLAs vote in the election of the President of India. But the number of people an MP represents is much higher than the number of people an MLA represents. So we need to bring some parity in the votes of an MP and MLA. And this parity is achieved by the process of weighing the MPs and MLAs votes. And it is being done with the help of Mudaliar formula of weightage of votes. This formula ensures uniformity and weightage and determines the value of the votes by the weight of each state's population. So the value of the vote of an MLA of a thickly populated state like Uttar Pradesh is more than a less populated state like Goa. Value of the vote of an MLA. The formula to determine the value of the votes of an MLA of a state is as follows. Value of the vote of an MLA of a particular state is equal to the population of that state divided by the number of elected MLAs. This is further divided by 1000 to basically keep the number manageable. According to the 84th Constitutional Amendment Act 2001, unless and until the population figures of the first census to be taken after 2026 have been published, the population of the state for calculating the value of the votes of an MLA in the election of the president shall mean the population as ascertained by 1971 census. Now, this is the formula of the value of the vote of an MP. So, the value of the vote of an MP is equal to the total number of votes of the elected MLAs of all the states divided by the number of elected MPs. Proportional representation through a single transferable vote. The President of India's election is held with the system of proportional representation through a single transferable vote. Two diagrams have been made below in the slide. On the first diagram, we have first past the post. This system is used in the case of parliamentary or assembly elections. Under this system, a voter marks an X or a cross sign in front of the candidate of his choice. Of course, nowadays we have the EVMs functioning on the same principle. On the second diagram, we have single transferable vote, which is used in the case of the presidential elections. In this case, instead of marking a cross mark in front of the candidate of his choice, the voter, in this case, the voter is an MP or MLA, he marks his preference. That is, in case of the first count, now in the case of the president, there's an electoral quota which has to be attained by a candidate to be declared elected. I'll talk about the electoral quota in the subsequent slides. So the candidate marks his preference 1, 2, and 3. So in the first count, my vote will go to, for example, as per this diagram, the candidate is Z. In the second preference, if the count is done, it will be candidate A. And if no one is elected, even after the second count, because they don't achieve the electoral quota, then my vote will go to candidate Y. Of presidential elections in India. The presidential and vice presidential elections in India are conducted as per the Presidential and Vice Presidential Act 1952 as amended in 1977 and 1997 by the Election Commission of India in the following stages. Notification of election by the Election Commission of India. Appointment of the returning officer and assistant returning officers by the Election Commission is the next stage. After that, the candidates who want to stand for the election of the president as a candidate, they file their nomination papers, which is scrutinized by the Election Commission, and the candidates can withdraw after a specified time. The MPs cast their vote at New Delhi and the MLAs in the respective state capitals on the date the presidential election is to be conducted. The MPs can also cast their vote in the state capitals with prior permission. The electoral quota, which I was talking to you about in the previous slides, is the minimum number of votes to be secured by a candidate to be declared elected as the president. It is determined by the following formula. Electoral quota is equal to total number of valid votes divided by number of seats plus 1 and adding 1 to the figure obtained. The required electoral quota is 50% plus 1 votes of all the valid votes polled. Votes. The first counting begins after rejecting the invalid votes. Invalid votes are those votes in which the MPs and MLAs, instead of marking 1, 2, and 3 or giving their choice of preference, they mark a cross mark, or in any other manner, it is an invalid vote. The total value of the votes of each candidate is determined by adding the value of the votes secured by him from the MPs and the MLAs. Hope you remember, the value of the votes of an MP and MLAs is different. In fact, the value of the votes of the MLAs of different states is also different, as it depends on the population of that state. If a candidate secures the electoral quota, then he or she is declared elected. But if no candidate secures the electoral quota, then the second count begins. That means the counting of the second preferences marked against his name on the ballot papers begins. The candidate who secures the lowest number of votes, and he cannot become the president because his achieving the electoral quota is a remote possibility, is excluded, and his ballot papers are distributed amongst the remaining candidates. If any candidate secures the electoral quota after the second count, then he is declared elected. If not, then the third count begins. The count may be fourth depending on the number of candidates, and if the ballot papers have the preferences given up to the fourth one if 4 candidates are there. Let us assume no candidate is able to secure the electoral quota and remains the only continuing candidate, then he is declared elected even if he fails to secure the electoral quota. The election process of the president is criticized due to the following reasons. First of all, we say proportional representation. There's no proportional representation, as only one position of the president is to be elected. Yes, it is a single transferable vote. If the voters do not give their second or subsequent votes, then no candidate gets the electoral quota. Then it will be literally a deadlock. The Constitution of India is silent if 2 candidates get an equal number of votes. Nominated members, though, are not part of the Electoral College to elect the president, but are part of the impeachment process to impeach the President of India. The members of state legislative assemblies, though, elect the president, but they do not have a role in the impeachment process, and only a candidate who is supported by a political party can stand for elections. This is so because a candidate's name must be proposed by 50 MLAs or MPs and seconded by another 50 MLAs or MPs, that is total 100 people. And for a common man to get the support of 50 MLAs and or MPs is a difficult proposition. impeachment of the president. As per Article 61 of the Indian Constitution, the President of India can be impeached in case of violation of the Constitution. The impeachment process is as follows. The charges can be levelled, preferred by either house of the parliament. That means either house of the parliament can start the proceedings for impeaching the president. But these charges can be levelled or preferred only if the proposal to impeach the president is in the form of a resolution and is moved after at least 14 days of notice in writing and signed by not less than 1/4 of the total members of the House, which brings such a resolution. The resolution has to be passed by a majority of not less than 2/3 of the total membership of the House. Total membership here means the elected members as well as the nominated members of both the Lok Sabha and the Rajya Sabha. Once the House which brings the resolution passes it, then it goes to the other House. The other House can investigate the charge or cause the charge to be investigated. The President shall have a right to appear or to be represented at such an investigation. If the second House, after investigating the charge or getting it investigated, passes a resolution by a majority of not less than 2/3 of the total membership of the House, then the President stands impeached from the day the resolution is passed. No President of India has been impeached by the Parliament. Criticism of the impeachment process. The impeachment process of the President of India is criticized due to the following reasons. In impeachment, the nominated members of both the Parliament's houses are included. We have 12 members who are nominated in the Rajya Sabha. Until recently, we had 2 members who were nominated in the Lok Sabha. The elected members of the state legislative assemblies have a role in electing the president, but in the case of impeachment, only the members of the parliament vote. The term violation of the Constitution is vague and ambiguous. It does not specify what constitutes a violation of the Constitution, and Article 61 also mentions that the investigation of the charge or the charges levelled by the House, but is silent who will investigate the charge or the charges. And as stated earlier, the Indian Parliament has not impeached any President of India. There are some immunities which are given to the President of India. And according to Article 361 of the Indian Constitution, the President of India enjoys the following immunities. The President or a governor is not personally answerable to any court for the exercise of their powers while in office. If you have some problem with the conduct of the president, that can be brought under the review of the impeachment proceedings but not tried in the court of law. No criminal proceedings can be started or continued against the president or a governor in any court during his term of office. No court can issue arrest warrants for the president or a governor, and civil proceedings can be initiated against the president or a governor against things done in the respective personal capacities after giving them a notice of 2 months. Thank you, students. This is the end of part 1 of the chapter Union Executive President of India. We will continue this chapter in part 2 of the video. Thank you.